Motions to dismiss by defendants in debt collection cases, Part 1. Brought to you by Kenneth Gerbert at yourlegalleg.com. Your advantage if you're being sued by debt collectors. What do you do if you're being sued by a debt collector? You should consider filing a motion to dismiss. If there's something wrong with the petition itself, it doesn't identify the debt against you, doesn't include certain necessary things like the contract or complete itemization of charges in Pennsylvania, among other places, or if you were not served in the right way, you could lose rights by not filing a motion to dismiss right away, because filing an answer can waive, that is, let go these rights. Even if you wouldn't waive rights by not asserting them immediately, you might be letting a golden opportunity slip through your fingers. Everything you do to up the ante and raise the costs of the debt collectors increases your chances to win and makes it more likely the debt collectors will give up. So what is a motion to dismiss? A motion is the way a litigating party asks the court to take some official action. A motion to dismiss is a motion which asks the court to get rid of some part or all of the other party's case on the grounds that even if what the other side says is true, it doesn't give them the right they claim. For this reason, motions to dismiss are sometimes called motions for judgment on the pleadings or demurrers. In Pennsylvania, they're called preliminary objections, and they're probably called other things in other places. The crucial fact in all of these motions is that all the facts alleged in the pleading are taken for purposes of the motion as granted, just as if they had been proven. If the motion is denied, the facts will still have to be proven later in trial, but for the motion they're considered true in order to test the pleadings rather than the facts or proof. In the litigation manual, I illustrate the concept by supposing that a policeman has issued a ticket for exceeding the posted speed limit, only the ticket says you were going 25 miles per hour in a 30 mile per hour zone. There, even if the ticket says what the ticket says is true, and in this case specifically if it is, it simply doesn't state a violation of the law. A similarly basic example in the debt law would be where you sued the other side under the Fair Debt Collection Practices Act without alleging an action that violated the act. Or you didn't allege facts that would establish that the debt collector is a debt collector for purposes of the FDCPA, although this type of motion is rare where the debt company really is a debt collector. Many motions to dismiss seem to be calling the court's attention to some obvious or trivial mistake, a simple oversight perhaps. But a lot of times these oversights are serious problems for the debt collector. The obviousness of the pleading problem can hide a deeper problem of proof. If your jurisdiction, like Pennsylvania, requires every document supporting a breach of contract claim to be attached to the petition, the debt collectors can really almost never meet this requirement. But they file them by the thousands. It isn't just an oversight, not by a long shot. But if you don't file a motion to dismiss, they get away with it. If you're in Pennsylvania and being sued by a debt collector, you might consider a claim under the FDCPA, or consider asking for sanctions for willfully violating court requirements. But first, you file your motion to dismiss. That's called preliminary objections in Pennsylvania, and that goes for other similar jurisdictions too. How motions to dismiss work, a very basic overview. When petitions or counterclaims are filed, they're supposed to be following one of two types of pleading rules: notice pleading or fact pleading. The type of pleading rule required can make a large difference, and it's determined by state law. In other words, your state requires either fact pleading or notice pleading. One of your first actions as a defendant in a debt lawsuit should be to find out which rule your state follows. Most states require fact pleading. If your state does require fact pleading, then filing a motion to dismiss is as simple as looking at the elements, that is, the parts of the case that the plaintiff is trying to allege, its prima facie case, seeing if every fact necessary to prove that case is alleged, and moving to dismiss if any parts of their case are missing. Every part of the case must be alleged. They're not allowed to consider anything too obvious to have to plead. At a minimum, this includes facts giving the court jurisdiction over you, showing ownership of the debt, proper transfer in the case of a debt collector, your failure to pay, and some balance remaining due. As I mentioned before, in some courts they also must allege every single transaction giving rise to the debt in question and attach all of the documents that support it. Failure to do that is a reason for dismissal, but you have to ask. Your motion to dismiss is the way you ask. You might think that debt collectors who file millions of these cases per year would never omit a part of their case in the pleadings. In fact, they do so quite often, and this is because of the nature of their business. They buy huge numbers of supposed debts with minimal paperwork, file cases by the truckload, and rarely get challenged by defendants or the courts. It's easy for them to make mistakes in the pleadings, and they often do. And sometimes they do it on purpose. For a simple example, consider again the filing of a claim of breach of contract in Pennsylvania, where a plaintiff in such case must either state the terms of the contract or attach a copy of it. Debt collectors almost never do this despite the rule because they can't. They don't have the contracts. The huge majority of these cases are still won by default, but those who defend simply file preliminary objections. Eventually, the cases of persistent defendants get dismissed with prejudice, but for each case that gets dismissed, probably thousands of inadequately pleaded cases result in default judgments for the debt collectors. Where the jurisdiction is notice pleading, a motion to dismiss is much more difficult to win. Notice pleading means that a petition must give the party being sued some general idea of what he's being sued for, and in some courts this is such a vague standard that it's almost impossible to succeed in your motion to dismiss, unless the debt collector actually names its theory in a heading, as they often do, and if it does not state all the elements of an obvious claim, you'll have to file a motion for a more definite statement, which is beyond the scope of this video. Timing: when to file, what to do after you do. There are two aspects of time that you got to consider when you're filing a motion to dismiss. The first is whether you must file your motion to dismiss before filing an answer. In my opinion, it's always a good idea to file a motion to dismiss on any basis before filing an answer. There are two reasons for that, a practical reason and a legal reason. The practical reason is that you might win. I talk a lot about the value of fighting in my videos and writings, and you'll win a lot of cases because you're willing to fight. But if you can win without fighting very much, that's even better. A motion to dismiss could end it all quickly and easily for you. And the legal reason: any motion that goes to the form or understandability of the claim is usually waived, that is, lost, if you file your answer before the motion, since if you can answer the petition, it's assumed you understood it. Any motion that goes to the court's power over you is also waived if you file an answer before the motion, on the theory that by filing an answer you're consenting to the court's jurisdiction over you. A motion that goes to the substance of the claim or the power of the court to hear that sort of claim can be brought at any time. If the court doesn't have the right to hear cases of the sort that are brought against you, your consent would not give it that power, even if you wanted to. The problem is that it isn't always clear which is which, and better safe than sorry in my opinion. The other question of timing is whether you have to file an answer after filing a motion to dismiss. Not on any part of the case that you've moved to dismiss till after the court decides the motion in general. We'll talk further about timing and about argument of motions in the next video on this topic. Protect what's yours and don't let the debt collectors rip you off.